Welcome to the Supreme Court of Kansas. We meet in special session today to hear oral arguments on one case, and I will call that case on the docket at this time. Case number 113267, Luke Gannon et al., v. State of Kansas. 60 minutes aside has been allotted. I will now ask counsel to rise in place and state their appearances for the record.
Alan Root, John Robb, and Jessica Squadron for the appellate.
Good morning, Mr. Chief Justice. Toby Krause and Paul Chalmers on behalf of the Office of Attorney General Derek Schmidt for the State of Kansas.
Very well. Do we have any preliminary matters to take up before we begin oral arguments? For those of you who like to keep track of such things, we will be taking a break after the conclusion of the state's opening on their argument, which I'm told is going to be about 48 minutes. But sometimes we ask questions and the time gets extended. So for those of you who like to plan your morning, that is our intention. Counsel, you may proceed.
Thank you, Your Honor. Mr. Chief Justice, and may it please the Court, Article 6, Section 6B declares that, quote, the legislature shall make suitable provision for finance of the educational interest of the state. Those 15 words are the alpha and the omega of this Court's inquiry here today. In Gannon 5, this Court held that SB 19 made substantial strides but failed to meet that standard. In response, both chambers of the legislature passed two bills and the governor signed SB 423 and SB 61 that together add over $1 billion into the old school finance formula that this court in Montoy 4 held substantially complied with Article 6, Section 6B. Because of that, we ask that this court dismiss this case and allow the school funding formula to operate as it's intended and allow the parties to go forward. I have three arguments that I plan to make today. The first is that the funding formula the legislature passed and the governor signed is adequate, it is equitable, and third, that dismissal is appropriate. If I could, I would first like to go to adequacy. I think there has been evidence in Gannon 5 that the SB 19 funding regime was a lot like the old finance formula. That continues with the new two funding bills that came forward. The change is it's a little more targeted, adds a lot more money, and addresses the equitable concerns that happened in that case. The legislature heard a variety of evidence, made its legislative decision on the basis of those policy choices the body made, and then the governor signed it. Why is it reasonably calculated to produce the results? The reasons are, history tells us, in Montoy 4 and Gannon 1, when you put money into the old system, results will follow. That's what the legislature anticipates with this regard, and that's what experience tells us will happen.
So the state agrees that money makes a difference.
I think this court has said that money makes a difference, and we're not here to argue differently. We're here to say that the funding regime that the court has previously identified as being substantially compliant with Article 6, Section 6B has been satisfied.
Let me ask you about your safe harbor argument. As I understand it, what you're claiming is that the legislature and the state wanted to get back to the old Montoy regimen of the number and then with inflation. And that makes some logical sense to me until you come up 5 years short. And it seems to me what you're saying is we're going to use the Montoy safe harbor, but we're going to stay 5 years away from where the number should have been. You're funding today's number 5 years from now, right?
I believe that that's correct.
Why?
The 5 years.
How does that make sense? I can understand saying in 5 years we want to be at a certain place using that same methodology. But what the state's decided to do is in 5 years, we're going to be here. And how do you get there?
So let me back up. I've got 3 points to address in that, Your Honor. The first is, let's start with the text of the Constitution. The text of the Constitution says suitable funding. This court in USD 229 says there's no metric by which we can measure. That's a suitability is a malleable standard. We look at the Montoy 4 decision as substantially compliant, but not the floor. That was the target. Montoy 4 was the target of 522. What the legislature did is it actually expended more money than what the target was. If you look at what I believe the difference is, I think there are 3 points. It's context, relevance, and then discretion. The context is, I think if you look at the calculations for 423 and Senate Bill 61, you're about $46 million per year for inflation. I think that's the rough number. If you put that into context, the average spend for school funding in the state of Kansas is $6.5 billion. I did the calculations last night, so you'll have to bear with me. This is my Excel spreadsheet, but I believe it's 3/4 of 1%. In context, it's the state's position. That's not a constitutionally significant number.
Here's my problem with that. The district court made a finding, and I'm trying to, all you guys have gotten away from the fact that there was a trial with findings, and we're an appellate court, so we're not going to decide that Dr. Taylor is more credible than Dr. Pikus and John Myers. I mean, we're just not going to do that kind of thing, I don't think. But I can't get past the idea that the finding of the district court was that $4,492 base state aid per pupil was provided at a time, I think the words of the district court were that it was constitutionally compliant or what constitutionally compliant legislature using that number. Okay, fine. I just don't understand why you don't bring it forward to inflation for the year 2023 and phase it in if you want to. I mean, I buy the logic of phasing. But you eventually get back on track to what the district court found. And to do anything else gets away from the factual findings of the district court, doesn't it?
Well, so there are a couple of things. I think we go back to the text of the Constitution. What is the constitutional floor? Under your theory, Montoy 4 would be the constitutional floor, and I'm
it's not my theory. It's the district court's finding. I mean, you cited it. You said, "Hey, we want to do this safe harbor deal," and you cited me to the page where the district court made that finding. Okay, fine. District court made that finding. Now let's live with it.
If that's the constitutional floor, that's a different issue. I don't believe that's what the district court found, and I don't think that's what this court found in Montoy 4.
Well, can you tell me what you contracted for with the West Ed study? And I'll tell you, there's a lot of frustration here, I think, on your part, on our parts, the plaintiff's part. And it goes back to the history of this case, and if this isn't kind of a deja vu, we have all been here before a moment, I don't know what is. I mean, we have 14 years ago, you all commissioned Augenblick and Myers to determine what a constitutional floor would be and costs would be. Out of that came a legislative post-audit study in the Montoy litigation. That gave us and you an idea of what it would cost. Fast forward to this year, you commissioned West Ed to estimate the minimum required to produce an educational system calculated to achieving the Rose standards, constitutional compliance. Then you hire another expert, Dr. Levin, to do a peer review. He validates the report. And it seems to me, and maybe this is, and maybe you can explain why it always occurs this way, but when we have litigation that involves basically evaluation, plaintiff produces an expert, you produce an expert, and there's a battle of experts. Here, you all are always battling your own expert. And it just doesn't, it puts it in a posture that doesn't make good litigation sense. And it seems like you base your constitutional compliance to the floor based on what you're willing to spend and not what your own expert says it's going to cost. And explain to me why that isn't so.
Two things, Your Honor.
What happens here?
Sure, and I'll do my best. Two things. The legislature passed a bill that mimics Montoy 4 in the standard that was at issue there.
That you disputed all along in Montoy. I mean, it's rather ironic that you're employing a Montoy standard that you didn't want to employ at the time, for sure.
But in Montoy 4, this court held that it substantially complied. The legislature has enacted a bill that complies with that. So that's what the legislature did. Backing up to Dr. Taylor and your point, I don't have the contracts in front of me, but I think they were in the record. What I would say is it reminds me of President Truman, who said he wanted a one-armed economist. Because on one hand you say this, on the other hand you say that. That's what we have with the expert, and that's a risk the legislature can't take in the remedial phase. Changing from class to successful school models to a different model is a risk that the legislature can't afford in the remedial phase. We have to be right, and the safest thing to do was to go back to Montoy. So while there are a lot of different opinions out there, the legislature, in its prerogative, made the decision to go the safest route possible to make sure that the schools open on July 1 or whenever the fiscal year suspends.
But if the safest route is Montoy, why didn't you go with Montoy?
I'm sorry.
If the safest route was Montoy, why didn't the state go with Montoy?
Well, we believe we went with Montoy Plus. We identified in our brief why it's more targeted than Montoy was, why there's more money put into special needs where the at-risk students are, the bilingual. So we believe that it is a better Montoy fix. And if it's just a $50 million issue, we believe the context of that isn't significant. This court has never indicated that the Constitution requires a particular measure of inflation, and we believe that the attributes of Senate Bill 423 and 61 have greater enhancements and more likelihood to address the educational needs of Kansas students. So we actually believe that it's a better model than what the SDF-QPA was.
Focusing on the history of base state aid per pupil, or base as we now refer to it. When you say that we were meeting Montoy 4 approved what was then legislatively enacted, a figure that was never, that was then rescinded. But that was what was approved, and that was $4,492. It takes you under this plan, it looks like, without looking at inflation until 2021 to reach that number.
Yes, a couple of points. I will trust your math. There's a spreadsheet put out by the Board of Education and by Legislative Research Department that identifies when that is, and we accept that. I will say that the calculation of base and base state aid, the weightings are a bit different, and the numerators and denominators are different. So the goal is at the end of the 5-year implementation period to be at the Montoy period. That's absolutely right.
So again, you're not asserting today that you're at Montoy 4, you're asserting that in 5 years from now you'll be at Montoy 4.
We're asserting that this funding regime meets Montoy 4, yes. And consistent with Montoy 4, I think it was a 3 or 4 year phase-in period. Same thing here. Is the Montoy 4 was a goal, that's what we have in this situation.
So to accept this plan, we have to accept that students will be underfunded for yet another 5 years?
If you accept this plan, you will find that this is substantially compliant, just like this court did in Montoy 4. There was a multi-year phase-in period, just like it is here. If we go back, there's $1 billion going into the system, 218 million, I believe, last year, 197 this year, and then it continues forward. So it is a fulsome funding system that is going into place. The base amounts are codified, and they will go forward and be implemented. So it's not a wait for 5 years. This is a significant input of additional money. We mentioned in our brief multiple times, over $1 billion in state aid. I looked at the funding regime for the last 10 years. It took 10 years to add $1 billion of additional funding. We're doing it in 5. We're doubling the pace, adding the money into the system.
Can you help me understand how base was calculated for this year or any other years? It looks like reverse engineering. We're going to spend this amount of money, so then if we do the math and calculate it out, that ends up with this number for our base number. Is that kind of how it happened, or?
I am not familiar with the operations of the formula. I know the formula is set forth in the language of the statute. What the policy choice was to get to a particular base year, I'm not certain. What I know is that I think the March 28, 2018 hearing, which we cited in our response brief, I think there's a video, it's about an hour-and-a-half meeting. The legislature, or at least the House, talks about why particular funding regiments were selected. Montoy plus inflation gets you to that number. How they segregated it out, base in year 1 versus year 3, I'm not certain. It's certainly not in the statute. It's textually in there as to what the mechanics are, but the policy decisions that was behind the legislature, to the extent you can ever estimate what that is, I'm not aware that that's in there. All I know is that the operation, or the people that calculate it tell me the operation will get you that number.
Okay. Is the same thing true then? The way it's set up is we have these set numbers in the statute until we get to 4,713 for base, and then from that point we start applying CPI.
I believe at the end of the 5-year period, I believe it's CPI Midwest, I believe is the correct one. I'd have to look.
So has the legislature made a judgment that 4,713 base is the appropriate base going forward? Or again, is it just kind of a matter of this is how much money we were going to spend and that's where we are?
I think the testimony in the March hearing that we cited is that they were angling towards the Montoy 4 old funding formula. That's the desire, that's the perceived safe harbor that the legislature took, saying if we fund to this method, it substantially complies with the Constitution and the school doors remain open. I think that's the overriding goal. Whether or not we could divine the intention of any single legislator or calculation that he or she may have made, I'm not certain the record is sufficient to do that.
I want to ask you about Exhibit 45 on your side of the deal, which is that table that shows up in the April 2nd amended supplemental report from West Ed. I don't understand. You then use that table to say that if we go with what you're proposing here, that we'll have a 91% graduation rate in 5 years or a 95% graduation rate. And I don't get that, because the table starts in the 2016-2017 school year. It says the graduation rate was 90%, only we know it was 86.1. So how do you reconcile that?
Forgive me, I don't have that table with me. But what I would say is that the legislation that is before this court does not attempt to or purport to reflect the Taylor study. I don't believe it. Again, I don't have the...
Well, your argument was that if we use this little table on this amended thing, we only needed to put in a couple $100 million,
right.
And we put in a bunch more, and if we only put in a couple hundred, we'd get a 95% graduation rate, and, you know, you're welcome. And none of that's keyed off of reality of what the current graduation rate is. I mean, you would have to pick up 9 points between now and your end date. And I don't understand that. So how do you get there?
I think I understand from our brief what you're talking about. What we were saying is the SB 423 and 61 provide a particular amount of money, which is less than the maintenance level that Dr. Taylor mentioned. Is that tracking? Right. Okay.
And it'll achieve X.
Right. So her calculation rate, the 2 compensatory models were attempting to get to 95% graduation rate, a rate that no state in the union is close to meeting. And once you get a 5-year funding surge, then you would maintain it by adding that maintenance level. Our point is that maintenance level, standing alone, will add to the scholastic achievement of Kansas students, as indicated, I think it's Exhibit 45, I'm guessing it's a supplemental report. Dr. Taylor and her outfit were asked, what is the impact of if we just take this maintenance level? She opined to the legislature, is my recollection, that it would provide meaningful advancement towards students' increase. What that metric is, I'm not certain. What I do know is that in Montoy 4 and Gannon 1, this court recognized that the old formula, which the legislature has funded, leads to meaningful results that is substantially compliant with Article 6. We were only showing that this was consistent and reasonably calculated to meet the educational interests that Article 6, Section 6B requires the legislature to do. There may be additional funding regimes that could have been selected by the legislature. That's a policy choice they could have made. What we're attempting to do is determine whether or not this funding regime satisfies or at least gets to the constitutional floor. If the legislature wants to go above that floor, that's within its discretion. This court's task is to determine whether or not the constitutional floor has been satisfied.
If we were to fashion, since you put the exhibit into the deal and said this is what was going to happen, if we fashion a remedy, would the state be okay if we held you to those performance standards?
Which performance?
The ones that are in Exhibit 45 in that table.
Those would be the Dr. Taylor.
Yeah.
Actually, I think part of the problem with Dr. Taylor's study is that she attempted to divine what Rose meant and was unable to identify what those standards are. And so she went to what's called the ESSA standards, Every Student Succeeds Act, I believe. Probably have it written down here, the citation. 20 U.S.C. Section 6311. That is a federal mandate that requires the State Board of Education to provide certain aspirational goals. And within the statute, it requires ambitiousness. I believe Dr. Watson indicated that the ESSA standards for the state of Kansas constitute a moonshot. That's the standards by which Dr. Taylor created her model. That is not the standard that the legislature chose, and it's certainly far beyond what the Constitution minimally requires.
So you wouldn't want to be held to the performance standards in your exhibit?
Backing up, that exhibit is what the legislature provided to the state of Kansas. We submitted what the legislature gathered when this court told the legislature to show its work. So there is a series of documents. We can't divine what is and what is not relevant to the legislative process. What I believe is that the text of the statute before this court has nothing to do with the funding regime that Dr. Taylor proposed. She proposed a goal line of 95% graduation rates, and I believe all subgroups, something that no state in the union has attained. I believe 91% is the highest in the nation in Iowa, and that's a far cry from that aspirational goal. So no, the answer is no, we would not like to be held to that standard. The legislature was presented it and specifically rejected it, choosing instead to go to the old formula that this court found substantially complied with Article 6, Section 6B.
Counsel, I'm a little unclear. Was the legislature not clear to Dr. Taylor what they wanted from her?
Your Honor, I was not a part of the process, and I don't know what their mode and method of communication is. The only thing I know is I have reviewed the contract that the legislature has with Dr. Taylor, and I have reviewed her report in which she gets to the ESSA standards.
So we don't know whether the legislature was not clear, and that's what led her to this path that you are disavowing today, or whether the legislature was clear and she just went rogue, which led her to the path you're disavowing today.
I think what I'm saying is it doesn't matter because the legislature didn't adopt what Dr. Taylor, her study, suggested. What the legislature did is it funded the old formula that this court found substantially complied. Whether or not the legislature got what they intended from Dr. Taylor is beside the point from a constitutional level in the question we have today.
So the legislature could have done what they did without the benefit of hiring Dr. Taylor, is that correct?
If they wanted to, they could have. I think what,
But isn't that what we're left with today?
say that again, I'm sorry, I didn't follow.
Isn't that in effect what's happened as of today?
Yeah, so the legislature has.
They just went back to what you call the Montoy 4 substantial compliance levels of spending and brought it forward.
That's correct. The legislature, I think we identified in our brief, started in December with a special committee. They hired counsel, they hired experts, they listened to the stakeholders. They took, up until the very end of the session, as Your Honor knows, enacted a bill that essentially is what this court deemed substantially compliant in Article 4, or I'm sorry, in Montoy 4, which is what the legislature did. Had they chosen not to hire Dr. Taylor, we'd be in the same place, yeah.
All right, thank you.
A lot of Dr. Taylor's work was focused on remediation. Does that have a role in what we're looking at today?
So
Do we look at the school children who we have held have not been adequately funded? And is there a constitutional obligation of the state to bring those students forward to where they should be if it had a constitutionally adequate funding system? Or do we just kind of ignore those students and move forward to look to see if you put in place a formula that works prospectively?
again, and I will say the answer is Dr. Taylor's study and the results are immaterial in our view to what the legislature passed in Senate Bill 423 and Senate Bill 61. However, Dr. Taylor's remediation period was attempting to get to 95% graduation rates, and so whether it was a good idea or a bad idea is a decision that I'm not here to defend. It was the legislature's to have made. The legislature could have said, you know what, Dr. Taylor, you're exactly right. We want to go with what you have suggested instead of the Montoy 4. But
Well,
the
let's set
legislature,
aside Dr. Taylor's, what she said was necessary, and just go to the general heart of the question. Is there a constitutional obligation to remediate?
we are unaware, and I do not believe that this court has identified a constitutional obligation to remediate. Rather, what this court and the legislature has done is the legislature has attempted to put forth good faith efforts to fund to what it believes the Constitution has done. This court in Montoy 4 said what you did is substantially compliant. In other decisions, Gannon's 1 through 5 has said that it is not. Try again. And so I don't believe that this is like a tort victim, an identifiable plaintiff tort victim that would have to be compensated. Rather, the constitutional burden upon the legislature is to provide suitable funding for the provision of the educational interest. It gives rise to no private cause of action that I'm aware of on behalf of Johnny or Susie's school child. Does that answer?
Yes.
Okay.
While you're paused here, I want to talk about the 5-year delay.
Yep.
You and plaintiff quibble over the percentage of inflation. But it occurs to me that there's a present value problem even if inflation is 0. If you have a teacher that finds that she would be able to accomplish her mission much better with a Chromebook or an iPad or whatever, even if it costs the same next year or the year after, the fact that she hasn't been given the money to buy it this year has resulted in a loss of use. And for the student, that's a detriment. In other words, there's a use value to that money, it seems to me, with what it can buy, separate and apart from your quibble about the rate of inflation.
I think that is a reasonable question to have, and one that was reasonably presented to the legislature. They made a determination that we're going to fund Montoy 4 plus inflation. That's what SB 423 and 61 is. We're going to phase it in over 5 years. Once we get to that phase in, we're going to have inflation coming back. There is, I think I mentioned, a 0.75% dispute as to whether or not the legislature could have or should have. Could they have done so? They could have. Did they have to as a matter of constitutional law? I'm unfamiliar with this court's cases indicating that they did. That's the dispute that this court has to determine, is whether or not that's a constitutionally significant issue.
And
No,
switching gears,
Sure.
you mentioned a couple of times the $1 billion. That includes catch-up payments to capers, correct?
It includes 95 million into capers, yes.
Yeah, and those are catch-up funds to
Well-
strengthen its soundness. Right, correct?
I'm not certain how the best way to characterize them. All I know is that if they weren't made, there would be a detriment to the school system. So it may be 90.
Well, let me ask this. I asked your predecessor, Professor McAllister, whether those payments would make $1 difference in the retirement of any teacher, and he conceded no, it would not, and that it was a catch-up. He conceded it was a catch-up to make the system sounder, and that it was a very, very collateral item that you can attract better teachers if your overall system is more sound, perhaps, but he seemed to concede that that was not a compelling issue for adequacy. So I take it that you've gone back to that argument that making the system sound because of neglect over the years is an integral part of adequacy.
I would never want to disagree with my teacher and my respected colleague, but I think you have to look at what it is. It's $95 billion of additional money, part of a $1 billion system that the legislature could have put towards roads, bridges, healthcare, social services, or something else. The legislature made a conscious decision that the funding of the education needed this $95 million. Whether that was a wise one or not, the legislature made provision for the funding and believed it an important and integral process. So whether it's characterized as a catch-up or not, it's still money that hits the system, and I'm quite certain that the people who receive that money believe it's an important aspect. So
Who receives that money?
well, I think that the teachers and the employees of the school districts will ultimately receive it.
But it won't change the amount of their retirement. It's
No,
not a
but-
401k.
But what it will do is it will make sure to continue to strengthen the education system, and this is a holistic approach to the education system that we have to look at. It's $1 billion into the education system.
But they have a defined benefit retirement system.
They do, and if this 95 million didn't hit that system, it would be $95 million short, and I'm quite positive that my learned colleague would be complaining that that isn't into the system. And so I think the legislature has made a policy choice, an appropriation choice to spend the state's money towards the education system, and it needs to be given credit for that holistic input of funds.
Counsel, a housekeeping question in a sense here. You've talked about how the legislature has tried to adopt the Montoy model and calculate it forward. Appendix 48 that you attached has a table which laid out the application of the inflation in calculating that $522 million number. It's not altogether clear that that was, whether or not that was presented to the legislature. Do you have any objection to us considering that as part of the legislative intent or evidence of how they got where they got?
I'm not sure that I have an objection to it. It was produced by the Legislative Research Department to try to capture what happened on the March 28th hearing that was identified. So I think it's, for lack of a better word, it's an explanation to folks like me who didn't attend the hearing, and it shows what the math and the calculations are.
Right. My question is, do you have any problem with folks like us looking at that for the same reason?
Yeah, I don't think we do. I think it's something that this court could take, I think, in all of the Gannon decisions, judicial notice of.
Thank you.
And I think it's consistent with probably Exhibit 50, which is what the Department of Education did as well.
Let me move you over to the 15% mandatory LOB. which there's been some objection to. Does that have any practical positive effect today?
I think it does. And what I see it as having a practical effect is it provides a floor beneath which no school district can reduce their education system. So for example, there is a $1 billion influx of money into the public school system. There could be a school board that would say, you know what, we're getting enough money, we're going to drive down our LOB range. So we have a floor. It's now included within the whole system. In addition, the weightings are applied to it. This court has expressed some concern that if we go LOB, all of our money for LOB, it gets away from the weighting system. And so there are a lot of positive attributes. In addition, it's like what I mentioned earlier, it's additional money that is guaranteed to go to the school system.
I'm not sure your better answer was that no, it doesn't have any effect, because it seems to me there's an equity issue here. The state mandates a 20 mil tax levy by all school districts. And the only reason why that's equitable is because there's recapture. So the Burlingtons of the world put 20 mils in, that produces more than the school district needs, and it goes to the state treasury. Now we've got this mandated state component, but it's 15% of the budget. And so in Burlington, it takes less tax effort to generate that 15% than it does in Galena, correct?
I'm not familiar with Galena, but I would assume that's correct.
This is the cliche of school
Absolutely.
finance, that we talk about Burlington and Galena because they're
I'll accept it.
the richest and the poorest.
Yes.
Okay. So how is that not an equity problem? If this thing has positive effects, how is that not an equity problem? Because poor Galena's got to tax itself a lot more to generate that 15% than Burlington does.
Yeah, and I think we cited in our brief, if we didn't, that's my error. Every school district in the state of Kansas exceeds that 15%.
I know that, which is why I think your better answer was this doesn't have any effect, because they're already doing it.
So I disagree.
But you told me that's a positive effect, and I'm saying if it has got a positive effect, it's got an equity problem.
If this court wants to address the equity in the 15%, its case has already resolved that issue. That's why there is no equity concern. It both is beneficial and it's constitutional. This court has previously said that LOB funding equalized to 81.2 is constitutional. That's what's going on here. The only thing the 15% floor does is prohibit school districts who want to take the influx of money and reducing their amount of LOB beneath that. So we're making sure the money stays in the school system. We're equalizing it to what this court has previously found constitutional at 81.2.
The way I've looked at it is that if this were 1992, when this formula first was born, and a lot of school districts didn't have an LOB, forcing them to go up 15% and only equalizing to 81.5. Of course, back then it was less, it was 75th percentile. But even still, forcing districts to impose an LOB where it's not 100% equalized would be an equity problem.
Well, a couple of things. I think this court has realized or recognized in multiple occasions that every school district does this and uses this for the educational system. So this isn't a if you want to do it. This is a method and means in which to provide public education in Kansas. Everyone does the LOB system. Everyone gets equalized at 81.2. In fact, most of them are far beyond that. And there is no equitable concern that's different from whether you impose a 15% floor or whether you do not. They're still assessing a percentage of LOB to their constituents. The state is still responsible for equalizing to 81.2, which this court's cases have recognized are constitutional.
We really haven't touched on this. We've maybe just barely touched on what I'm going to inquire about next, and that is kind of the interplay between the state board's authority under Section 2 and the legislature's obligations arising under Sections 1 and 6. What is the interplay, and how much does the state board have well, they have a stake, but how much does the legislature take into account the state board setting standards in order just to achieve the floor that we talked about?
Well, so I talked to
Well,
Justice-
there's different obligations, constitutional obligations.
That's right. There are local school boards, state boards, and the legislature all have differing roles here. I mentioned to Justice Biles talking about how we looked at the maintenance level in Dr. Taylor. I think the state school board has requested 893, and we're pretty close to that. I think we're at about 97% of what the state board has selected. So again, that's another metric by which we can measure it. But getting to the constitutional question, does the legislature have to be controlled by what the policy judgments of the State Board of Education?
Controlled, or what's the interplay? I mean, you can't ignore it either.
Sure. The state, Article 6, Section 1 says that the legislature has to provide for the funding or for the operation of the schools. Article 6, Section 6 says that the legislature shall fund it. Article 6, Section 2 says that the State Board of Education, once the legislature creates and funds, must supervise. Article 6, Section 5 says that the local school boards should also exert some control. So I think they're part of a triad that work together, but the Constitution is plain. The legislature is the one that sets the course. The State Board of Education supervises. It's the one that complied with the ESSA standards, as I mentioned, and set those as aspirational goals. And that's kind of how the schools march. The local boards then exert additional local control, whether it's LOB funding or anything along those lines. So I think they work in tandem, but in no event does anyone get out in front of the legislature.
So as far as their role, as far as the type of legislation, strictly advisory.
The Constitution says they have general supervision.
Right.
Of the schools.
Once the funds have been made.
Once the educational policy in Article 6, Section 1 has been set, and then the funding has been set, then the state school board comes into play to have general supervision. That's right.
Let me ask you about the severability issue. I mean, you've made the argument that if we hold this law to be unconstitutional, that we're actually violating the Constitution and violating the federal Constitution. But the legislature has put a non-severability provision in this legislation, which to me has the effect of saying we're strapping on a suicide vest and putting a few dozen triggers on it and then sort of daring us to push one. How does that non-severability provision not violate the same principles that you're saying we would be violating if we found the law unconstitutional?
A couple of things. I don't believe in this round of briefing we have made that argument to this court. What we have said is that we want this court to keep the schools open. The state of Kansas's policy is to keep the schools open on July 1 or whenever the fiscal year turns over. Section 47 in Senate Bill 19 does still contain a non-severability clause. We believe that would only be triggered if, for example, there were equitable issues at play. The funding should go forward. This isn't a trigger that the state is pushing this court to do. We believe the safer course and the more constitutionally compliant course is to allow the funding to go forward, allow the schools to open, and if there is a concern, for example, on equity, that this court gives specific direction to the legislature to consider in its next session.
So let me just take that answer one step further. Let's just say that we have a problem with the 15% mandated LOB, just to make up something. What are you telling us we do with the non-severability provision that's in this? I mean, it seems like we got to wrestle with it.
Yeah.
So what do you want us to do?
I think that the non-severability portion would be, as applied in that scenario, perhaps unconstitutional because $1 billion of funding is much more constitutional than $0 of funding if this court were to strike everything down. And so the end result of this situation is that school funding and schools should open.
I didn't understand the answer.
Let me try again.
Okay. here's this 15% mandated LOB, which I would argue doesn't have any effect at all because everybody's already got more than 15%. But let's set that aside and let's just assume that the law is unconstitutional for that reason alone. Do we blow up the whole formula?
No.
Under the severability provision? What's the rationale for not doing it when the legislature has said that we should do it?
Well, because if this court did it, it would be violating Article 6, Section 6B, which is...
So is the non-severability provision itself unconstitutional?
As applied in that scenario, I think it probably would be.
Okay.
Because, $1 billion or $6.5 billion of funding is more adequate than $0 of funding. And so if you look at how Senate Bill 19 came into play, that was a successful schools model, and those were particularized metrics and how they did the weighting, and you talked to my predecessors at length about what those were. I think that may make sense in that situation of like, well, don't, for example, change the weighting from 0.454 to 456. That would affect how the legislature does its work. In your scenario, everything is okay except for the 15% floor. It's likely that the legislature would have passed it without that. And so I think the safer alternative for this court and the one more constitutionally compliant is to allow the funding to go forward and sever.
Just so I'm clear, rather than saying that the non-severability provision is unconstitutional, you're saying that we should apply the traditional legal analysis that we would apply to a severability provision and just say, look at the whole thing, how would it work? If it works, then it really doesn't matter that the legislature said you can sever it. If it doesn't work, we just kill the whole thing. But it works in reverse on a non-severability.
Yeah, so
you see what I'm saying?
I do, because I looked at this, and this court's cases typically are severability clauses as opposed to non-severability clauses. But I think you have two different modes of analysis. One is constitutional. Constitutionally adequate funds need to get to the schools, and that's the state's position. The second is that this court could look at, I think it's the Brennan truck case or whatever this court's test would be. So we do believe that at the end of the day, the state of Kansas believes that schools should open and this funding regime should go forward because it's substantially complies with Article 6, Section 6.
Mr. Krause, before you run out of time, you indicated that you would like to have this dismissed. And obviously the desirable outcome, but it's a phase-in program and laws could be repealed, laws can be amended. How would it benefit anyone if we agreed with the adequacy, if we agreed with the equity to dismiss this action when there's things that have to happen down the road across the street in order for it to come into full compliance?
Yeah, so our response would be this court's task is to determine whether this funding system satisfies Article 6, Section 6B.
I thought your argument was it will ultimately in 5 years or 6 years.
No, we believe consistent with Montoy 4, it substantially complies. Just as it did in Montoy 4, and this court dismissed the case, that's the appropriate remedy in this situation. And there are important reasons why this court would or should want to do that. And that is because the legislature as a body has to be able to exercise policy choices and make policy decisions. It can't always come to this court under the superintendence of bearing the burden of, beyond the rational basis that would traditionally be afforded. It doesn't make for good school policy. It doesn't make for good relationships between co-equal constitutional branches of government. We believe that the more important...
No, go ahead.
No, we believe that the more important rationale is to find whether this system complies with Montoy 4, which we believe it does. And in that case, the situation calls for dismissal to allow the parties to go back. If the legislature changes its mind in 1 year, 2 year, or 20 years, I'm quite positive that the Kansas history would suggest there will be additional litigation in which the typical give and take of the litigation process can go in its natural course. The legislature can operate in its natural course. This court can get removed. I think we talked about the facts of the 2012 panel. We're so far removed from what the trial court was. This court needs to deem substantial compliance and allow dismissal so that the process can go back to an equipoise.
So the answer is if next year you decide to do something different, maybe cut in half what you agreed to today. The solution is file another lawsuit rather than hold you to compliance of what you agreed to in this lawsuit?
Yeah, so a couple of points. One is, if situations change, that is a legislative prerogative. That would be different than today. Today, the law before this court substantially complies with Article 6, Section 6B. Dismissal is the appropriate remedy. If a litigant, post-judgment...
What prevents you from passing some legislation that you know in 3 or 4 years you're not going to do, but just to get this case done with, we're going to pass some legislation that's going to add $2 billion into the system, and then in next year you change your mind. So the remedy is, or the solution is to file another lawsuit rather than comply with what you agreed to do in this lawsuit.
Well, let's be clear. What happened is the legislature passed a law and the governor signed it. That has the force and effect of law going forward. Another legislature could make that determination that they do not want to go forward.
Counselor, I don't understand. This year's legislature can't appropriate money for next year.
It has codified the amount,
But it can't appropriate.
That's correct.
Next year, the legislature has to appropriate the money. Even though it's the law, they have to appropriate the money. So I don't understand your argument. If this requires 4 more or 5 more legislatures to appropriate the money, I don't understand how you say it's in compliance now.
Because the law was passed, and this is the specified amount of money that is going to be put into the funding system if nothing happens.
But that's just advisory. The next legislature comes in and says, we're not going to spend the money. That's just an advisory. They don't have to change the law, they just don't appropriate the money, right?
Let's back up. What happens is the better alternative to back up and allow this court to sit in the middle of that school finance litigation. We would submit the answer is no, that the more natural course is to say that this money, this funding system has been set. $1 billion are set to go into it. There's no more evidence that the legislature will change the amount as it will keep its promise. So to use, I believe,
like it did in Montoy.
Again, different legislature. And in that situation, the Gannon plaintiffs came in and filed a different lawsuit. That's the way that this situation could, better yet, should work, is if there is a change in the funding, then the plaintiffs will have an opportunity, a new set of plaintiffs will come in and then present that to a court will make a determination. This court will then sit as a court of appeal instead of a court of first impression each legislative session. So the money has been set forth in the funding system that complies with Montoy 4. This court's sole inquiry isn't to predict what the legislature is going to do in 3 years. It's to determine whether the funding system complies with Article 6, Section 6B. And in Montoy 4, this court found substantial compliance under substantially similar circumstances.
My understanding is that the state of Kansas is now in violation of the Constitution as ordered by this court, and that you're charged with the burden of showing us that you are now in compliance with the Constitution, and you're asking us to find that you're in compliance based on a promise to do things in the future. And to me, that's not remediation as of today. That's remediation as of 5 years from now.
Well, it's consistent with Montoy 4. From a funding system, we believe that this is a better fund. This is more targeted and more beneficial than Montoy 4, and it's a phase-in period just as this court found in Montoy 4. If the situation changes, there's no evidence that it will, additional litigation can be filed.
There wasn't this discussion in Montoy 4. When everybody in the room in Montoy 4 presumed, based upon the promise of the state and all those participating in the litigation, that was a 3-year plan that was going to be fully funded. This discussion never took place about what if funding in the 3rd year was cut or wasn't complied with. And that's why we're proceeding with so much caution here, is that we didn't appreciate that scenario coming forth from that.
Well, and I would submit that that's a better method of doing business is following what the law says in the SB 423 and 61. If there is a change in it that is material, a plaintiff may then file a lawsuit saying the law that you have passed has been changed. It now violates Article 6, Section 6B, allowing the perpetual litigation that is known as Gannon, which was, I think it was filed in 2010.
Right.
This is a never-ending cycle.
I agree. That's yeah.
As I was getting ready for this case, I remember the Justice Cardozo, Cerboni, and Bogg. We're never going to get out of it. Right. The proper remedy is to dismiss it. If something changes, allow a plaintiff to file a lawsuit, allow them to try to prove their case, allow the legislature to defend it, and allow things to go forward in this proceeding. But this never-ending cycle of litigation should end for the benefit of the state and the schools.
Counsel, let's look at, let's look at the timeline. You reminded us that Montoy 4 was decided in 2006.
Yes, sir.
And within, I think, about 3 years, 4 years, as you indicate, the plaintiffs filed, well, first I think they wanted to resurrect Montoy, and this court denied it. And then we said, if you have a new lawsuit, file it. So they did in 2010. Today it's 2018, and you're telling us that now the legislature is in compliance with the funding levels of Montoy 4 12 years ago. Am I correct so far? Using the formula.
And inflation to get it up to.
And inflation,
right, yes.
Sure.
So that's the...
And
yes.
Some might suggest that we are here today because of what the legislature did not appropriate in 2007, 8, and 9. So just so I'm clear, is this something that you would be satisfied with occurring again in the future?
I was talking to my predecessor yesterday. I'm not sure I ever want to come back again like this. But I think the better situation is if the legislature changes, as it did 3 years after this court found substantial compliance, the better metric or the better opportunity is to allow a plaintiff to file a lawsuit, identify what their particular constitutional concerns are based upon the particular actions of the legislature that they believe offends the Constitution, allow a trial court to hold a trial, bring their proof to the court, make a decision, and then the parties may appeal if it needs to. That would allow the legislature to return to its typical business, this court to return to its typical business, and the school systems to continue to operate without the ever-present threat of litigation. Is the school going to be funded? Is it going to be shut down? The better metric and mechanism, while that discussion may not have happened in Montoy 4, it may have been fortuitous that it didn't, because that's the better method.
But following, it sounds to me like the plaintiffs, or at least the plaintiffs' counsel, because there's Montoy and Gannon, followed your advice, and they filed this lawsuit 8 years ago. And today, the state is saying, parenthetically, at last, close parentheses, we are compliant with Article 6. And so my question is, your position is a repeat of that process is the way things should happen if the legislature would not continue funding the plan they've laid out in the last session and in this session with these 3 Senate bills. Is that correct?
If there is a belief that the statute has been changed or that the funding system has been changed and that change is a constitutionally significant one, any plaintiff may have the opportunity to file that lawsuit.
And my question to you again, if you would answer it, is 8 years between the filing of not being adequate and not being equitable until today, when you are telling us that the state has complied with those constitutional requirements, that's just the process in your view, and that's satisfactory.
Well, I don't know whether it's satisfactory. I'm not trying to duck the question. I think that is the process. And once constitutional compliance has been found, dismissal is the appropriate remedy. So I think the answer is yes, that's the process.
All right, thank you.
Thank you.
And isn't the real effect of that, at least according to the trial court findings and then what we have found, that we've had 12 years of noncompliance? unconstitutional system?
This court has not previously found constitutional compliance since Montoy 4. That's right.
And that's the better system, is to have 12 years to resolve the situation?
Whether it's the wisest choice or not, it's the constitutionally compliant metric. The legislature has a burden to fund to Article 6, Section 6B. Once it has done so, this court's job, we believe, is done, and dismissal is the appropriate remedy, yes.
Any further questions? Counsel, we've interrupted your presentation with questions. Do you need a minute to wrap up this portion of the argument, or do you think you've made your points?
I'm going to go ahead and sit down and reserve the additional time. Thank you, Your Honor.
Very well, thank you.
May it please the court, Alan Roop for the appellees, along with John Robb and Jessica Skladzian. Good morning. I recognize that this was this Solicitor General's first oral argument in this matter, and I appreciate his remarks. I do want to read something by way of introduction that was written before he was involved in this case. And the quote goes like this: "For all students statewide, those not meeting the reading standard went from 12.1% to 14.4%, and for math, those not meeting the standard went from 14.2% to 20.8%. The number of students statewide not meeting the standard set in math was 69,670 students, or 14.6% of all students. And in reading, it was 58,218 students, or 12.2%. These remarks were written by the three-judge panel in 2012. This case was filed in 2010. In Gannon 4, you said that these findings were supported by substantial competent evidence. If you look at what the state has proposed in the current legislation, they would like the state to have 71,000 students failing by the end of a 5-year period. They would like to see 85% math and limited language arts. That will take us in 5 years right back to where the trial court decided we were in 2013, and you found substantial compliance in 2014. It'll take it 5 years to get back to the beginning of this litigation. So the state's current position is to set a goal where we were when the panel declared the system unconstitutional, and they want to have 71,000 students failing by the end of 5 years. The state is funding a level that its experts estimate will result in 15% of students failing, testing at level 1, at the end of a 5-year phase-in. If you take 473,334 students, that's in the legal max, and you take 15% of that, that's where I get the 71,000. They want 85% of all students meeting ROSE capacities. We think that doesn't meet the adequacy test.
What does? And how do we determine that?
The measuring stick, I think, is achievement and compliance with what you've indicated were the ROSE factors. And what I would suggest to you is that when the state went out and hired an expert, Dr. Taylor came back with some scenarios that we'll talk about in a minute. But the scenarios they came back with, I don't think she went rogue. I think she went rose. And what your standard is the rose standard. And the rose standard, once it's achieved, once we have all those kids in a position where they are achieving, then I think that's when it ends.
So no student in Kansas can be at level 1.
I don't think we can say no student. I will
How-
tell you that.
What is I mean, is 15% appropriate?
I'm sorry.
Is 15% an okay number? I mean, what is it 15, 10, 7, 5?
Well, 15% has already been declared unconstitutional, so we know it's not that. And we know that the Article 6 requires improvement. And so we know that needle's got to move. And we know to move the needle, because the state recognizes that money makes a difference, it's going to take additional resources. I'd like to be in the conversation at some point, whether 15 kids or 20 kids not getting those opportunities is constitutional or not. We're not even close to that point. And in the study done by Dr. Taylor, the cost function, she identifies what resources are needed in order to be remedial and get the current funding level to a point where we can have the kind of achievement that we want and that you've identified as necessary in order to be constitutional. The Constitution requires suitable funding, adequate funding, and we're not there yet.
Part of the problem I'm having in looking at all of the information is that sometimes we're talking about level 1, sometimes we're talking about level 1 and 2, sometimes we're talking about some portion of level 2. But it seems that we have said rose is a minimal standard. So are we really just talking about those who are failing under level 1 and everything else is aspirational?
There is always some conversation about level 2, but level 2 is recognized by the state board as being non-proficient. It's not being college ready. There has never been any dispute among level 1. Those kids that we are failing in our system are clearly at the bottom. So I would tell you that the one thread of consistency through all this is level 1. From time to time we dispute level 2, and it varies up and down. But what we're concentrating on are those kids that are non-proficient. The state board currently takes the position, and it's the law of this case that levels 1 and 2 are non-proficient. So I would take the position that when we talk in terms of levels 1 and 2, and Dr. Taylor talks in terms of necessary to move kids to levels 3 and 4, that that's the current measuring stick on proficiency.
And the board gets to set that.
That's the board's role. They are to supervise the educational system, and that's what they do, and that's their role.
Setting aside school or student performance for a second, I'm having a hard time getting past the findings of the district court, because it just seems like we are way, way past where you guys were when you tried the case and the findings that came out. It seems to me that the district court, sort of in credence to the safe harbor, the Montoy safe harbor approach, I'm not saying they sailed into harbor, but the safe harbor approach, it seems like the district court did find that Kansas schools were adequately funded in 09 and 10 based on, had the state kept its promise and funded at the 4,492 level. And so if we, as an appellate court, if we have a district court finding that says that was working, why can't we just adjust for inflation and call it good?
For a number of reasons. 8 years after committing to provide a base of 4492, the state is only providing a base of 4165. Adjusted for inflation, and when they talk about Montoy and the adjustment for inflation, remember that in Montoy, the fix was to raise the base and achievement increases over time. They went back to the first payment, the first year of Montoy, and took that number and adjusted it for inflation. If they wanted
up to this year, and then said they're phasing it in 5 years later.
Right, to 5 years later. If they wanted to be true to going to Montoy, what they would have done is take the last year of Montoy and adjust it for inflation. And what they've done is go back to the cheapest, they have a tendency to do that, and adjust that number for inflation. At the end of the 5-year phase-in,
what's the difference? I'm sorry, counsel. What's the difference between those two approaches? Because it seems like if you're, regardless of whether you're starting at the low number or a middle number, if you're properly adjusting for inflation all the way along, you're going to get about to this. I mean, for these purposes.
I'm obviously not explaining it well enough, because as I remember Montoy, and your recollection is probably as good as mine on that, but as I remember Montoy, they raised the amounts and they looked at achievement increases in the plan. So I think as they incremented the amounts, that went up higher than the normal inflation rate. So going back to the first year and fixing the first year at the cheapest number, and then moving it up is the difference.
The VSAP increased more than the inflation rate would have been,
Right.
is your point.
That's what I'm saying.
In the early years of the phase-in formula, okay. But, same point. Why can't we just look at that and whatever, I mean, the worst thing you can do is trust judges with calculators, but somewhere along the line, make those adjustments based upon the district court's finding. I mean, I got to plant a flag somewhere in the district court's findings, because I can't do credibility determinations. I can't make facts. I've got to look here. And if not, then we got to just send this thing back and let you all do it again.
I don't know that I'll be around if we do it that again. But my point would be to go back to Montoy is really to pretend that Gannon never happened. And the problem is the state in Gannon stipulated that there were $511 million worth of cuts per year coming out of the system. And when you look at what that impact did to achievement in Gannon, you can't just go back and say Gannon never occurred, those cuts never occurred, we didn't do damage to the system, we're going to start.
That's your remediation argument, right?
That's exactly right.
Okay.
And I would tell you, if the standard is rose, I don't see it as remediation as much as spending what's necessary to achieve the standard that the Kansas Constitution requires.
If we sign on to the idea that remediation is appropriate, don't we have to send it back to figure out factually what's required?
Not at all. Because all you have to do is say, this is what the Kansas Constitution requires, and you've said that with Rose. You know from their own study, maybe an admission, but that you know from their own study what it's going to take. Their expert has said what it's going to take.
Yeah, I mean, the problem I've got with that is an appellate court can't make a credibility or a validity or even an admission against interest kind of stand. I mean, I know what you want to do. I just don't see how we can fulfill the function of an appellate court without finding facts to do what you want us to do.
Well, we are in the remedial phase.
Right.
So you look at what the solution the state has proposed is. And if I remember right, in Gannon 5, you suggested to the state that they do a study to determine what is necessary. And they took your advice, and they did it, but they didn't like it. So they took a scenario A and discounted that. Actually, they tossed it. Scenario B from West Ed, and they tossed that. There was a remedial phase that followed. There was a maintenance phase that followed the get kids back to where the achievement comports with Rose, and maintain that. I think it's a 90% graduation rate, and they rejected that. So they said, well, let's reduce the inflation number from 2.4 to 0.95. Let's lower the target from 90% plus to 85%, and let's cost out that. And that's what they've got. That's where we are here. And their trajectory, as I explained in the introduction, gets us right back to where we were when we filed the case in the first place. In 5 years. I didn't mean to be strident. I apologize. Okay. Let's talk about those levels, because I look at, and I want to put the West Ed approach in the context of achievement and the Rose standards, and I look at the situation like a ladder. Top rung on the ladder is achievement, high achievement. These are kids that are doing A plus kind of work, and it's at the top of the ladder. I think the next rung down, as you've explained, is the Rose capacities, and the next level down would be a lesser standard. You've called it a minimal standard. Then we come to the West Ed analysis of this. And I think the third rung would be the Taylor B study. And that's one in which you get only 60% of the kids achieving at levels 3 and 4. So you get over half, 60% of the kids who are proficient. And that leaves a 40% failure rate with Taylor B. Dr. Taylor had another scenario, Taylor A, and that gets you 90% of the kids achieving at levels 2, 3, and 4, and that's the 10% of the kids at level 1 failing. So that would be the next rung down. Then, and there's a question whether it's actually on a rung below, she has a maintenance approach. And the maintenance approach she suggests is a lesser standard. It has changed with the second maintenance that the legislature did that they have adopted. But this has only 85% of the kids performing above level 1 and 15% of all kids failing. We talked about that. That's the 71,000 number. That's what the state has funded. I think her maintenance originally in the report was to follow either scenario A or B. So if the gap is closed and kids achieve because of what she costed out in A or B, then the maintenance was instituted to keep that higher level achieved in A or B continuing. Now, here's the important part in terms of what this court has been concerned about and what has been talked about before. And that is that in this scenario, Dr. Taylor has indicated that the cost is going to be significant, 1.7 to over 2. And it does have some meaning in the context of all the school finance litigation, because we commissioned Myers and Pikus, and they came up with a similar number. And West Ed aligns with A&M and legislative post-audit when it's updated. That number is 1.771 billion. And then what they've done with all these studies is pick a method that they've adopted, which if you look at Appendix 15, you see all the studies, including West Ed, in our chart that we provided for the court. And then far below is the outlier. That is what the state is pitching to you now is constitutional compliance. If you go to the second page of that, it's adjusted for inflation, and it's even lower. It just doesn't get to where it needs to be in order to have that student achievement where it needs to be in order to satisfy those Rose capacities.
And where, getting back to Justice Lukert's initial question, where is that? You know, we're not concerned about a funding mechanism that's optimal. We're trying to focus on constitutionality. What's the floor? And why can't the state say, well, 60% is the floor?
The reason the state can't say 60% is the floor is because this court has determined what the constitutional level is, and they've looked at 60, and the trial court and this court have looked at those performance levels and said we're not adequately funding education and we're not complying with the people's constitution. So we know that part.
Yeah, let me take issue with that. I'm sorry to interrupt, but let me take issue with that because I don't think that's what's been said. We haven't tagged constitutionality to student performance. We said there was a finding of unconstitutionality by the district court. Some of the evidence of that were these performance standards, but other evidence was other things like the drop in the funding and stuff like that. So I hear you trying to say that the test of constitutionality basically occurs at the end of each school year when they take their whatever exam we would be requiring. And if they pass, then okay, and if not. And that's not it. The student performance was just a part of the calculus of going into that. And so isn't that right?
Yes, and it is a component. You look at graduation rates, you look at the trial court record where we had teachers and administrators and what's been called the boots on the ground testifying as to how kids are not being able to be provided the education that needs to be provided in order to satisfy Rose because of lack of resources. Let's talk moonshot for a minute. The state claims that what the Commissioner of Education meant by moonshot was unattainable. Well, it isn't. The graduation rate of 95% is being attained today in 76 out of 286 school districts. They already exceed 95%. Taylor A less than 10% at level 1. In Kansas, we've got about 1,250 schools. There are 180 schools that meet this already for math. There are 119 schools that meet this already for language arts. Taylor B, which was more than 60% at level 3 and 4, 118 schools meet this already for math. 133 schools meet this already for language arts. There is one school district that has the trifecta that meets all three of that criteria, Blue Valley. And where I think all the kids in Kansas on the achievement gap, all the kids in Kansas need to have the opportunity through structure and implementation to allow those kids to achieve the Rose factors.
Well, isn't that what Rose says? I mean, we adopted in Gannon 5, we quote, a system of education must have as its goal to provide each and every child with at least the 7 following capacities. And 1 and 6 of those deal with one deals with a rapidly changing civilization, which means that it's a fluid standard, and 6 deals with competing with surrounding states, both for jobs and academics. And so it seems to me that by those very words, refutes that it's a de minimis standard, or that it applies to only 80%, because it says each and every child must have the opportunity to, the goal must be for each and every child.
I agree with you, and I would add college ready and specifically career ready. That's where we want our kids when they graduate from public school. And with the funding right now, and you can see it everywhere in the trial court record, with the funding right now, the schools don't have the resources, but they have the knowledge how to do it. And some schools do have enough resources to get there, that moonshot. But
Yeah, I'm sorry, I didn't mean to interrupt.
Huh?
I didn't mean to interrupt.
I'm sorry, I'll defer.
Last I knew, Blue Valley, which I think we're all very proud of the success that
No
district has
question.
had, was ranked like one of the top 5 school districts in the country. Are we really trying to move our whole, I mean, yes, aspirationally, we'd love to move our system to where all of the school districts were doing that. But it comes back again to that question of reality, of what is the realistic goal of the Rose standards. We're trying to provide the resources, but that doesn't mean that every student is going to meet the resource. We're providing a system that would allow for that, but it doesn't guarantee student success.
And I would agree with everything you just said, but the question is failing 71,000 kids allowing for a system to give those kids the opportunity to achieve? If saying the target is not 100%, it's going to be 85%, which is where we were when the trial court made its finding. It is failing those kids, giving the opportunity to succeed. And I would tell you it's not, especially in light of the trial in this case and the trial record, where it was explained that those kids can accomplish considerable when they have the resources, when the schools and the teachers have the resources to do that.
And the plan in front of us has a lot of targeted money for those kinds of programs, or at least the potential for those kinds of programs.
Compare with the need, the targeted money is not sufficient to close that gap.
And how do we know that?
Because the gap hasn't closed, and because of what their study has told them they need to do in order to do it. They have the burden of proof. They have to show you that because of what they are doing, they are closing that gap or will close that gap. And they haven't done that.
And you're obviously correct. They have the burden, so I'm not asking you to disprove their case. But I guess my question really is more of a procedural one. How do we today make that judgment, or do we have to remand so that evidence can be presented about how those targeted money might move the needle?
Gannon 5 gave them a charge, and that charge was to come in here and show you they had a system to achieve what you've defined as the measuring stick with regard to the Rose factors. They haven't done that. So the question becomes, do you now give them yet another chance? Or do we declare that what they have brought to you in light of what their own experts have told them is necessary, is not constitutional, and take remedial action as a result of them failing the Kansas kids with regard to their constitutional compliance? That's where I think we are. I think in the remedy phase, with regard to the remedies here, we have outlined for you what we think is necessary in the remedy phase to accomplish what we're asking, and we would suggest that this court enter a finding that the legislature should appropriate at least enough money to meet the Kansas State Board of Education's request for additional resources for fiscal year 19, fund a base of $5,090 for fiscal year 19. That will cost an additional $506 million. Enter a finding requiring the full funding of special ed at 92% of excess cost as required by the statute. Phase in additional increases in the out years so that they approximate the additional 1.7 to 2 billion in 2016-17 dollars indicated by West Ed, and once and for all incorporate a CPI index during any phase-in period to reach adequacy, and remove any requirement that the LOB be linked to a protest election requirement. We've outlined that in our brief. Remove any requirement that LOB funding be mandatory or equalize any mandatory LOB to the 100th percentile.
Counsel, just so I'm clear, if I understand what you just told us in summary fashion, looking just at adequacy, we should say that one of these scenarios in the West Ed study is what the Rose standards require. Is that correct?
I think I would tell you that based on Dr. Taylor's analysis, one of those scenarios is what the Rose factors require.
And the establishment of those factors is the prerogative of the State Board of Education?
And they have aligned with the Rose factors in terms of what their expectations are. That's correct.
And if the state board were to say, for example, we want 100% proficiency from all students, the legislature's response is, well, we don't like it, but that's what you told us, so I guess we have to do it.
I would tell you that in terms of what the state board sets as the target, they've not set it at 100%. I don't know that they would. I think the ESSA standards are lower than that. But in terms of what the state board says is necessary, it is the legislature's responsibility to get somewhere between being constitutional and complying with what the state board has said. I'd love to have that conversation, but we're not there.
I'm afraid I'm not understanding what your answer was. My question is whether the state board sets proficiency standards at 5% or 95%. That is solely the prerogative of the state board, and the legislature has no input on that?
No, that's where you come in. It's got to be at a constitutional level, at some at some point that constitutional level is defined, and you've defined it as through structure and implementation, allowing all Kansas school children the ability to achieve the Rose factors.
And if the legislature does not fund to those levels that the state board said would be sufficient for these standards, then the legislature, quote, runs the risk, unquote, that this court could say, legislature, you got there, or no, you didn't.
Right. That's exactly right. And this court has said, that's why we're here, has said that level is not sufficient to achieve that standard. And this is just a matter of constitutional compliance. I'm not, and we're in the remedy phase, so in terms of fact-finding or any weighing of evidence in this phase, the legislature has the obligation to show you that what they have adopted does what we've been talking about, and that proof isn't there. And the proof isn't there because of all the things that we've talked about.
Given what you've said about the need for student performance, you know, one of the exhibits in the pile caused me some concern. It shows the balance in the at-risk funds going up pretty substantially over a year, and I'm trying to figure out if the need is there, why we aren't spending that money, why those balances aren't there. I mean, it really kind of looks like you're asking for money that you're not spending.
Well, we're absolutely into the weeds on how at-risk dollars are handled. But I'll tell you, you can ask any administrator in any school district, and they will tell you that what is in the at-risk fund doesn't sync with what they're spending on at-risk kids.
It just doesn't make sense to me that the amount of dollars goes up given this crying need.
I will repeat what I just said. I think that's the only explanation I can give you off the cuff.
Okay. Let me move you over to the 15% LOB mandate while we've still got time. I mean, I look at that thing and I just don't see what you're complaining about because everybody's above 15%. So what difference does it make if the legislature wants? I mean, to me, it's sort of a public relations or make somebody feel good kind of thing because it didn't require a school district to do anything because they were already forced, if you will, to be in deep into the LOB dollars. So why should we care about that?
Well, I think we can agree neither one of us would care about it if it were equalized to 100%. But it's not. It's equalized to 81%. And everybody is forced to do it because it's mandatory.
And they are doing it already. And they were doing it before.
I understand, but it's being used for necessities. And so some school districts are being required to spend $1 that is worth 81 cents. And other districts are able to spend the $1. And that's the equity violation between that $1 and the 81 cents. If it's equalized to $1, everybody gets the same $1. But if it's not, it's lesser money for some. And back to the Galena Burlington analogy, that money comes harder for districts that are poor.
And you and I understand that, but this doesn't have any practical effect.
It may not, but it's still an equity violation. It may not have a practical effect, but if they're cannibalizing money and money is tight and there aren't sufficient resources, that difference between unequalized money and equalized money to a school district like Galena means a lot.
If it doesn't affect the behavior of your clients, how do you have standing to attack it?
Well, I think this court has recognized that we are in a position with our clients to affect the outcome on a statewide basis.
There's no school district in the state that this affects. because nobody's is forced to raise up to 15%, because they've all had to put their shoulder to this thing a lot harder over the years because of the dependence of required dependence for local option budget. I get back to, if nobody has to change their behavior and it's not doing anything, how do we find it unconstitutional?
Because it's an equity violation. And it may not have an impact, but it certainly is in existence, the difference when funds are being cannibalized. It may not be that anybody right now is affected by it, but it is an equity violation. And I would suggest to you that if they just did that on the general fund as opposed to the LOB, or they said it can remain optional, it wouldn't be a violation consistent with your previous rulings. But as I recall your previous rulings, there was a problem when there was that disparity in school districts' ability to spend. And the fact it's not equalized is the violation that we're pointing out to the court.
Are they going to have to change the name of the LOB because it's no longer optional?
The local compulsory budget, yeah,
Right.
I agree. That's what they'd have to do, at least for 15% of it.
I had a couple housekeeping questions, one of which my colleague asked opposing counsel, and that was whether or not this court can consider at least two different items that are in the record on appeal, one of them being the April 23rd, 2018 memo from Edward Penner, the principal research analyst, addressed to Curtis Tiedemann, and then the same two parties, only a memo dated May 1, 2018. Can we do anything with those?
Consistent with what you have done in the remedial phase and what the parties have said to you they're comfortable with, absolutely. You can refer to both of those.
Okay. Let me broaden this. Is there anything in the record that has been presented to us that you think we should not be considering or somehow taking judicial notice of?
No, there's nothing. And what made me pause is there is a part of the Taylor study and what Dr. Taylor provided that I'd like to, in fact, supplement our brief with, because I think it has important information in it that I want to discuss with the court.
Before you go there, can I, in relation to the Chief Justice's question, ask you specifically about your reports, Dr. Baker, and the Picus report? As I understand it, the state's taking the position that we should not consider those because those reports were not put into the record of any of the education committees. Would you respond to that?
Well, it was put into the record. It was put into the record, I believe, by Senator Hensley in a constitutional protest. The fact of the matter is, and you can verify this with opposing counsel, but the fact of the matter is there was no public hearings on this. We didn't have the opportunity to do it. And we were standing in the hallways waiting to do it, but we didn't have the opportunity. And the only way we could get it before you was to do it as a constitutional protest.
That brings me back to, I think it was Justice Biles' colloquy with counsel, and that is, we've got all these reports and peer review reports, and you're asking us, as I understand it, just to say, as is the state, make our decision based on the record in front of us. But I don't know, for example, how credible any of these experts would be, and usually that is something that's teased out at a trial but it sounds like you're comfortable with not getting that opportunity. You're just going to look at the record and say, we should choose this part over this study. Is that correct?
Absolutely, but I would not define your role as a fact finder weighing the credibility of witnesses. I view your role as looking to the state to see whether they have complied with your charge, which is to prove, they have the burden of proof, to prove that the Senate bill they adopted is going to achieve those Rose factors that you have indicated is the constitutional threshold for Kansas schools and for the legislature. And I think it's a simple matter of looking at all that you just indicated, not weighing the credibility, just looking at it and said, have they done what they said they were going to do?
But well, let's look at something beyond credibility of witnesses. It sounds to me like you may be asking us to make some findings. We find this part is better supported than this other expert's part.
There is no part in which they have shown you that the Montoy harbor, safe harbor that they call it, or that the funding that they've done in 423 will move the needle to reach now those Rose factors, or the definition as you've given it. So it's not a matter of sizing up their proof. It's a matter of whether they have the proof. And I would suggest to you that it's not like any other case that comes before you. When a party has the burden of proof, they have the obligation to persuade you and to prove it to you. And they haven't done it, would be my argument.
There also appears to be a dispute as to what inflation factor to be applied. I see a number of different factors in the record. You say one, they say another. It looks like maybe at least one of the experts has said a third. How do we determine which inflation factor would be appropriate?
Well, you can look at that and just apply common sense to it. The state's factor on their second addendum with Dr. Taylor was to take a 5-year look back into the recession. We took December of 2017, and that's the number we have, which I think was like 2.4%. And those are all factors that this court has looked at and been comfortable making decisions on in the past. You determine interest rates all the time.
But I think in the history of this case, we've relied upon the panel to make those determinations, have we not?
Yes, yes, you have.
Thank you.
Okay.
Before you get started with where you're going next, I want to talk about the inflation rate just a little bit. Is there a difference between the present value of those payments and the inflation rate, what they would buy it at in the future? Because ordinarily when we're considering the present value of money, time value of money, we apply a discount rate, very often the prime rate, which is a lot different than the inflation rate. Is there a reason that you added inflation rather than discounting the future payments on a present value, discounted value?
I don't think we added inflation. I think the state did when they made a 5-year plan. And what I would suggest to you is that embedded in that 5-year plan.
Okay, that's the state's plan. And so do you have an argument for us that inflation that they've used is inadequate when we're talking about present value of future payments? You didn't make that argument.
No, I didn't, Your Honor, but in terms of the inflation factor, I think that is a inflation factor that we had 2.4%. That's close to what Dr. Taylor indicated was about 100 million, 98 million a year. Their addendum, even if you look at that, it's 45 million a year at 0.95%. So it's a significant amount of money, and if the court looks at it as a range, it still doesn't accomplish what they've been charged with the responsibility of coming in here and proving to you. They haven't met their burden of proof.
We've talked mostly about adequacy this morning, and the state basically conceded or stated, yes, money can make a difference or makes a difference in achievement, but funding alone doesn't make up or account for differences in student achievement. It's not solely related on funding. There's a lot of other factors outside of the classroom that come into play.
Oh, I
and I looked through Dr. Taylor's report. I've looked through all. Where do those factors come into play in determining constitutionality of and meeting the Rose factors? I didn't really see it anywhere, because that really does. That's part of the equation. It's not all money.
Well, I would tell you to look in the trial court's record, because we absolutely litigated that issue on whether money makes a difference in terms of student performance. And
it's a factor. It may be a big factor, but there's other factors that come into play.
I absolutely agree with that. And there are some kids that, because of those other factors, cost more to educate, and we've got weights to affect that. And the system, as it works with the weightings, accommodates those other factors that are factors in achievement. But the problem is the structure right now is fine. It's just not enough money to drive the results. And that's the problem. That was the problem when we filed this in 2010, and it's the problem today. I want to briefly address what I think is important about Dr. Taylor's study, and it would be based on whether or not if you somehow accept the 15% as being satisfactory, does Dr. Taylor's, does Senate Bill 423 reach the level of achievement that West Ed claims it will reach? And that's that 15% failure rate. My argument to you is going to be that Taylor provides the estimates of achievement levels for various spending levels. That's what she did in the cost function analysis. That's the scenarios. But she also provided a different structure or distribution of the monies to reach those achievement levels. The state did not adopt her structure. And if you look at her report, there is, and at the state's brief, there's no evidence that the current distribution structure will achieve those achievement levels with the $423. And here's the reason. Taylor's distribution shifts massive amounts of money from high achieving districts to low achieving districts. And Senate Bill 423 doesn't do that. The only evidence that 423 will reach those achievement levels over 5 years is from Taylor. And her distribution structure is substantially different than the state's. So I would point to, and let me give you an example, Kansas City and Blue Valley under Taylor distribution. If you do the math on her report, the Taylor structure gives Kansas City, Kansas, $39 million more dollars per year than Senate Bill 423, and relies upon those additional dollars to hit the 15% failure rate by 5 years from now. Senate Bill 423 does not give this extra $39 million to Kansas City, Kansas. And without shifting that massive amount of dollars, Kansas City, there's no evidence, can hit the 15% target. In her material, Blue Valley is already hitting the targets. And under her structure, she would remove from them $60 million and reduce their funding in order to provide lesser school districts sufficient funds. So my point is, and this is not asking you to make any findings of fact, it's just look at what they have provided you. They have not provided proof that they are complying with your charge in Gannon 5. And we would ask the court, adopting what I've said in my brief, we would ask the court to enter an order that gives the legislature what the Solicitor General has asked for, which is specific instructions to the legislature on what needs to be done in order to meet your charge. They're asking for it. All you have to do is tell them what is necessary. Give them that roadmap. In the national discussion of school finance, Kansas has been a rational, common sense leader in the discussion. And what I would suggest to you is we're able to do this without strikes or without chaos. Our legislature in Montoy has finally responded. I think the legislature today will finally respond in taking direction. And if you are specific in what needs to be done, as we've outlined, I'm comfortable that I won't be here much longer on school finance before you.
What does our roadmap look like in your mind? Is it as far as the remedy goes, and if it's a multi-year phase in, and the status of the case, the discussion that we had with the state? What should that look like?
If you look at the last page of our brief, that's what we're advocating. We're not opposed to a phase-in, and that's why we indicate that you should treat this a lot like the Montoy case in giving them specific direction on what needs to be done this year, and then phase it in. But we're making a huge plea to you for two components of this: inflation and continued jurisdiction. Because what needs to happen is once you tell the legislature at their request what they need to do in order to achieve constitutional compliance, it's going to be important for you to retain jurisdiction.
Mr. Ruth, on that point, let's assume we find compliance. Your arguments have been considered and not accepted, and we find the state has come into compliance. Mr. Krause, he didn't say this, but he came close to saying this. Then if this court finds that this court has no jurisdiction to continue overseeing the case, do you have a response to that?
Well,
he can clarify that, but that's how I took his comment when he said we're looking at this law, not something that could happen into the future, and we can't do that. So do you have a response to that?
Well, yes, and my response would be the lesson of Montoy, where the court did exactly that, and the legislature in the third year of the plan reneged on what they said.
So you don't think it's a jurisdictional issue? And
No,
again,
I don't think
if
it's a jurisdictional issue. I think you have jurisdiction to assure constitutionality today and throughout what the legislature has promised you. All the deseg cases, all the prison cases, any case in which there is a violation of the Constitution and there is a plan to remedy that constitutional violation has had courts continuing jurisdiction in order to retain that jurisdiction and enforce the constitutionality.
Counsel, I'd like your input, and I'll also ask opposing counsel for his on a timeline. If what you say turns out to be true, and the court says, state, you're not in constitutional compliance, I've been looking at your brief, and it talks about all the substantive things that you are asking us to do, but there's nothing in there about a timeline that I'm aware of. So what I'm trying to find out is, as you're aware, in Gannon 5, we said, state you've not met your burden, but we will stay the issuance of our mandate till June 30, 2018. So with that in mind, take me from there on how you see this, your scenario playing out on a timeline.
Thank you for that question, because I was told by a couple of people before I started talking today that I needed to cover this, and I haven't, so let me do it. August 25th is when budgets need to be filed with the clerk. I think you need to work backwards from that. It usually takes mid-July to mid-August for school districts to have an idea of what they need to have in order to budget for it. So I think you have to work backwards from mid-July, and I would tell you as soon as you, I mean, we did our briefs with 7 days, and I would suggest that the faster this can be done with regard to schools and the budgeting process, the easier it's going to be to move forward. Does that answer your question?
In part, what do we do about the June 30 date, if anything?
With regard to the June 30 date, I would expect or hope that you would have an opinion before then, long enough for the legislature to react to it. In Montoy, there was a special session, and it may be necessary for the legislature. They wanted specifics. You give them specifics, and you give them until June 30 in which to accomplish that. And then in terms of what happens on June 30 if they haven't, I think we have discussed that in our brief, but we would ask for the opportunity before the system is declared void to talk about special exceptions in order to preserve security and not cause substantial losses.
One last question from me. We asked opposing counsel the same question, and that was the non-severability clause. Do you have a view on what impact, if any, that has on any of our decisions?
Well,
and a remedy?
With regard to the non-severability clause, I think your cases have indicated you have the ability to decide whether or not that severability clause is, or non-severability clause is constitutional or not. And I would suggest that it's not. And you have the ability to determine that.
All right, thank you. Any more questions?
Counsel, if you could just address something for me that you touched on a bit ago, which was the allocation that you said was resources that was different in the Taylor report than is being proposed by the state. You talked about the Blue Valley KCK dichotomy there as proposed. Would you see it that had the state taken its proposal but operated or plugged in a base more like you suggest they should be working with, given the weightings, does that come closer to reallocating or adjusting in the way that you argue is needed out of the Taylor
my
report?
whole point was that if you decide that 15% target, I think the trajectory on 15% is too low. So even taking their money and plugging into a system to some other system, I don't think is sufficient. I still retain the argument that more resources are needed.
Well, plugging in a higher base would require more resources.
Right.
But my question is, you criticized the difference in the allocation that was in the West Ed report, where money was taken and from higher achieving districts, put, at least for the time being, into districts that had a more expressed need. I'm trying to struggle with how that would differ from working with a higher base, which does have weightings, which will assist in allocating resources as well.
Well, I think I'm on track with what you're asking, and this is my fault, not yours. But I think with regard to what you've explained, if you increase the base to match the resources that are necessary, you could do it that way.
Two ways to get to the restructure.
Yeah.
Any more questions?
Thank you.
Did you have any further presentation?
No, Your Honor. Thank you.
Thank you, counsel.
May it please the court, Your Honor, I want to start where I began my initial thing, and that is Article 6, Section 6B. That is the beginning and the end of this court's inquiry. We've heard a lot of discussion today about what is, might be, or could have been decided. But what this court's task is to determine whether it meant what it said in Montoy 4, that the funding regime, as it was done then and today, substantially complies with the Constitution. There may be situations.
That's not true, counsel. In Montoy 4, it was substantially complied with the court's orders, which was to change the formula. There was never any blessing of the formula that came out of Montoy 4 in terms of the Constitution.
But what this court said was substantial compliance with that formula. The formula that you have before you today is better than that. The targeting is more attuned to what this court has subsequently said in the Gannon cases. The weightings, I think, went from, I have it somewhere here, point 456 to 484. We're addressing those. We've got $44 million in special needs. So this formula that is before you today is more targeted and directed at what the needs this court has identified before. We believe it's better than what it was, and what this court said in Montoy 4 and recognized in Gannon 1 is when it was funded to that level, substantial results, beneficial results followed. That's what we would expect going forward as well.
And our argument, I guess, that we're having back and forth here is whether you've done that because we need to move. Let's just take Montoy 4 and the formula the way it is. I still get back to why don't we just take an inflation rate and call it good? And if we do that, it's still more money than what you've put into these bills.
I'm not sure that it's more money, nor am I sure that it's as targeted as it is with this regime, nor am I certain that the Constitution was set by Montoy 4. This court never said that the constitutional floor was set by Montoy 4, so we could go below that. So for example, if the metrics were 0.456, perhaps 0.454 would have been sufficient.
Other than the finding by the district court that when if you'd have hit the statutory rate of 44.92, you were constitutionally adequate. And that's, I mean, I'm with you as far as what you're saying, but after a trial where you guys all fought it out, the district court made that finding, and that seems to be where we have to plant the flag.
Yeah, and I think that's what, if you look at the record and the formula that it's designed to match, I think that's what we're angling towards is the 4492. I think it's document 48 is Mr. Penner's memorandum that targets the 4492. I think we all agree to that.
Other than you're going to hit it 5 years from now for this year, and that's what I think, that's what doesn't make sense to me.
Well, and so what I would say is that in Montoy 4 there was a phase-in period, so I think plaintiffs agree that a phase-in period is traditional in this type of litigation.
The phase-in just gets you to where you would have been today. It doesn't get you to where you would have been 5 years from now. I can see making a calculation that says where do we need to be in 22, 23 or whatever it is. Or
yeah. So then the question,
school year, that's the number, and then just phase that in, and so by then you will be where Montoy 4 would have put you in that school year. That's what I just can't get that out of my head.
Right. And that's why it raises a question to me: is that less or right at 0.75% in inflation? Is that a constitutionally significant figure? I think that's what this court would have to decide. Previous cases, I don't believe, have identified inflation to that finite metric to be required by Article 6, Section 6B. In fact, USD 229 talked about that provision doesn't have anything that's that finite. I have a quote that I had pulled out there that I could read, but Article 6 has no finite metrics. Suitability does not mandate excellence or high quality. In fact, suitability does not imply any objective, quantifiable education standard against which schools can be measured by the court. That doesn't talk about the number of inflation, but it talks about, the inquiry is suitability here. It's not a finite metric that's constitutionally significant. The legislature has, in its discretion, the ability to consider the metrics and the measurements and the formulas and the weightings that have been applied, the way funds are directed, how those funds will be accounted, what the targets are. That's a legislative policy choice that the legislature traditionally has and has in this situation executed on. This court's cases, to my knowledge, doesn't have any finite distinction that would get to that 0.75% of inflation.
The Constitution also, we're talking about suitability of provision for finance. It also imposes a mandate that our educational system cannot be static. It calls for improvement. And that's a constitutional mandate. And I'm having trouble with something that we found was compliant in 2006 is the same, just needs more money in 2018. And like counsel said, it's just ignoring that a lawsuit took place. It's ignoring WestEd. It's ignoring all of that talks about that it can't be static. It talks about improvement. And what do we do with that? How does that advance a better quality in the state of education in Kansas?
So you're referring to Section 1?
Yeah, it talks about academic, scientific improvement. It's not a static kind of thing. And we've had, since 2006, 2018 was graduation, was just this weekend and last weekend. That's a whole student population. It hasn't changed since kindergarten for those kids to when they graduated.
So I would take you back to the Montoy 4 Gannon era. This court said in Montoy 4 substantial compliance, recognized in Gannon 1, when money was going into the system, we have result. What we have, the bill before you today is going to input $1 billion into the educational system. The person that's in 3rd grade by the time they graduate 8th grade will be at the Gannon 5 situation. If this were a remedial private right of action case, we may have something different to talk about. But what we're doing is we're improving the educational system, and we can only improve up to 100%. I read this Article 1, Section 1 language to say general improvement for the educational system. It has to continue to improve, continue to be better, but it's not a metric of if it's 94.4 today, it can't be 94.3 tomorrow. Who knows what those factors are, whether they're economic, sociological. I think what led to the problem in Gannon 1 was the recession. There are a whole host of situations. These are aspirations that the Constitution sets for the legislature. The legislature tries to design that educational policy. It then gives it to the State Board of Education to provide supervision, all with the ultimate goal, as I think we talked about in the Rose Standards. They're goals. That's where the legislature is heading, and I think that's what the metric is. Is it suitable?
Counselor, you said aspirational, but in Montoy 2, which we quoted in Gannon 1, it said the Kansas Constitution thus imposes a mandate that our educational system cannot be static or regressive, but must be one which advances to a better quality or state. So that's not aspirational, that's a mandate. We've said that is what the legislature must do. And you keep talking about discretion. Yes, the legislature has great discretion, and we've tried to reiterate that over and over again. You have discretion on how you do something. But what you do, the people of Kansas have said in the Constitution. And that's a system that advances to a better quality or state.
Yeah, I think the people have spoken in Article 6, Section 1, and the legislature has taken you at its word. There are a myriad of opportunities in which to comply with the Article 6, Section 6.
But you would agree that's not aspirational. It's not an aspirational goal for the legislature. That's a mandate.
It's a mandate to provide for the improvement. What the metrics are is an aspirational goal that either the state board can identify, the legislature can identify. There is no metric, as this court has repeatedly said, to measure suitability for funding. And that's what we're here today to talk about, is a suitability for funding. Article 1, Section 1 indicates provide intellectual, educational, vocational, and scientific improvement. It doesn't say there's a particular metric. It says that the regime has to be appropriate. I think it's the statute that adopted the Rose standards is 72-3811 or something along those lines. But that's what the legislature is doing to discharge its Article 1, Section 1 duty. What we're here today to talk about is its Article 6, Section 6B, provision of suitable funding for the educational system.
Counsel, you told me in answer to my questions that there was a 3/4 of 1% difference and you didn't think that was constitutionally significant. What is that 3/4? And let me tell you where I'm coming from. And again, remember my admonition about judges and calculators. But I just took Mr. Penner's inflation rates that he applied between 2011 and 2017 and averaged them, totaled them up and averaged them. It was 1.44% per year. So if I go out 5 years, that's about 7%. So I'm sort of, by doing that kind of guessing, that I'm talking about $250 million. And that doesn't seem like 3/4 of 1%. So I'm, again, recognize my admonition.
Yeah.
But where are you coming up with your number?
Your admonition applies equally to a history major. So let me go with you in my calculations here. If I look at document 48, Mr. Penner's calculations, I have $46.6 million is the average annual inflation rate that he's got there. I take that to the Kansas Board of Education.
Oh, you totaled up in the inflation adjustment amount, where I'm totaling up the percentage rate. Is that right?
Yeah, when I did this last night on my Excel spreadsheet, I was adding up the inflation adjustment amount. That's correct. Okay. So I go there. Then I go to the State Board of Education's state totals, all USD's school spendings. For the 2016-17 school years, we have $6.084 billion of funding. If you then move to document 51, which talks about how much funding is coming in, we've got $1.069 billion. I come up with roughly 6.5. I wrote it down here. I've got the spreadsheet at home, but 6.5 billion. 46 million into 6.5 billion. That's point. I don't have to go.
Per year.
0.765%. Right, and then you add it. You're right. So that gets up to maybe.
You and I are close.
Right.
I think.
Which is dangerous.
Which we ought to stop.
So that's how I get to that point. But the larger point is the context of, is that a constitutionally significant matter? This court's cases hasn't indicated previously that it is, especially when you consider what the weightings are and the analysis the legislature has done to direct and target those metrics. There may be better ways in which Dr. Taylor's study or anybody else's study would do this that could be above and beyond that. But we're talking about what's the constitutional floor for Article 6, Section 6B.
Counsel, I'd like to go back to a basic question, and that is, in Montoy 4, we basically had an A&M study that, as I recall, looked at performance by students, and the A&M study purported to find out what it would cost to improve performance. And I'm wondering, are we looking at performance in 2017 and 2018 of students today when it sounds like what you're doing is taking the formula and the base from 2006, applying inflation and saying, well, here's all this money, and because money matters in education and performance, we're meeting the standard. I grant you, you've targeted some money for at-risk students, et cetera, but what else are you doing to say that, yes, this money is appropriate so we can discount or disavow what Dr. Taylor did, which I understood was her charge? You follow what I'm asking?
I do, but I'm going to take a little bit of issue with the premise of your question. I think this court's inquiry is the constitutional floor of Article 6, Section 6B. Whether the legislature believed that Dr. Taylor's study was appropriate or not is a matter that is for the legislative discretion. That issue is not before this court. I think you talked about with opposing counsel that making determinations as to whether Dr. Taylor or the plaintiff's expert is the proper metric or is a proper metric is not typically within the province of this court. So I think that's where we would take a little bit of issue there. What the legislature did is it relied upon the history of when you fund the old, I'll call it the old formula, you're going to get results. This court has found, and I think the district court said, money matters. I don't remember whether it was A&M or LPA, they found a correlation to money matters. Okay. Going through the metrics of the system, we're going to get the results if the money goes in. That's what I think the legislature is entitled to rely upon and doesn't have to go out to get an additional study. I think that's a critical point. This court has said, show your work. That arose in the situation in which the legislature departed from the traditional funding mechanism that this court recognized had worked. If it came up in class and it came up in the successful school model. When you change a system, the legislature may have a duty to go test it, means test it, or something along those lines. That's not what happened in this case. What happened is they funded the old formula that this court has recognized provided demonstrated results, and I think the trial record indicates provided those demonstrated results. The reason this litigation was necessary is because the legislature didn't fund what the law had applied, and the results, as found by the trial court, were less than what was anticipated.
If the performance standards in the last several years were worse than what they were in Montoy 4 in 2006, how can you simply take the formula and apply input to that formula from 2006? Let's say if the proficiency level was 90% and today it's 50%. How can you simply put money in the formula and say, well, we know money matters, so it means it's going to improve up to where we want them to be? That's my question.
Yeah, and I think I'm understanding you. Our position is that the formula, when it was funded, was producing results. As I understand your question, it's in 2016, for example, this court has said that the funding system was unconstitutional and didn't produce those results. The legislature is entitled to rely upon the funding and the results that were obtained when the formula was funded. I'm not sure if I'm answering your question, and it's because I'm not understanding it. Is that what we're saying?
Dr. Taylor seems to think that we're behind where we should be, and therefore what I call surge money needs to be put in place.
Yeah, and I think our point with that is Dr. Taylor's metric that she was measuring whether we were above or behind ties into the ESSA standards, which is the 95% state graduation rates, which, as everyone would acknowledge, no state in the nation does. There may be districts or pockets that do, but that's the metric that she was saying we aren't at that 95% rate, and I think the statistics would back that up. And so I'm not sure that Dr. Taylor's metrics nor plan of attacking the deficiency she identified between the 95% and where we are germane to the discussion. Because what the legislature did is, instead of going with a new formula to address it in an approach that Dr. Taylor promoted, it went to something that was tried and true, that being the substantial compliance old formula that this court blessed in Montoy 4. And I feel like I'm not answering your question. It's not because I'm trying to dodge it. It's just,
no, I understand.
Okay.
I understand. I have no further comment on that question. In fairness, let me ask you the same question I asked opposing counsel, and I notified you this would be coming up. Let's assume, just for argument's sake, that we agree with the plaintiff and we determine that the state is not constitutionally compliant. He has said, gee, it'd be nice if you could get that decision out pretty quickly, so the legislature would have until June 30 to come up with a cure. With that in mind, just as a timeline, how would you see that playing out?
I'll answer that in two ways. First is the state's belief is that the schools should be allowed to open on time, and that's our primary goal. So that's our position. As far as mechanics, I leaned over and watched Mr. Chalmers to see if he objected to anything that plaintiff was saying, and I think the schedule is an appropriate one. The sooner the better. If there needs to be changes, the sooner that could happen, the better. I don't have any particular guidance that there is a trigger date that day one or June 15, June 20, that there's a meaningful difference there. But the sooner the better, because if there needs to be changes, that time is going to be necessary.
And what, if anything, do we do with the June 30 date that we established in Gannon 5?
Yeah, and I go back to our primary goal is to allow the schools to go forward. If you look at the last 2 years, adding $300 or $400 million to the system, plaintiff's counsel indicated that the results of the students in many districts were doing great. There may be additional places in which money could be directed. It's the state's position that money has been directed and results will follow. So we would provide or promote to this court, allow the school system to go forward as it has, and if changes need to be made, I think we said in our response brief, allow that to be done in this regular session next year.
So stay the issuance of the mandate once again until next June 30?
Assuming dismissal is off the table.
We're just
Right,
talking
sure.
about possibilities.
Yeah, no, and I think that's important, though, is allowing, as much as this court can allow the legislative process to be in a traditional mechanism and not what I would call a reactionary force to, we've got a decision on this date, we've got to meet this deadline. I think the most important deadline is letting schools start when they're supposed to, as opposed to the uncertainty. As I understand it now, we're in the budgeting process. I'm glad I'm not a superintendent that has to deal with that uncertainty. And I think it's giving that certainty to the legislator and the school districts is an important component.
All right. Do we have any further questions? We've taken a lot of your time with our questions. You came up here with some remarks you wanted to put before us. Would you like 60 seconds to wrap up?
Probably needs at least that, but let me see if I can organize my thoughts here. I think the non-severability that Justice Biles talked about is an important one. We don't believe that a statutory remedy that would require constitutional non-compliance is an appropriate alternative for the courts. I think we talked about a couple of ways to get to the result that you and I were talking about. And so the state does continue to believe that.
You're saying in school finance cases, not only do we have the typical analysis that we do with a severability provision, because there's a whole lot of law about whether non-severability is different than severability. But you're saying in a school finance case, an additional issue is whether the non-severability doesn't violate the constitutional mandate about having an educational system and that sort of thing.
Yes.
So we got two ways to skin this one.
At least two ways to do that, and then some atmospherics that would be the overarching federal obligations that, for Individuals with Disability and Education Act. And so there are a whole host of problems if this court were to trip one of the triggers, as you and I talked about earlier. So striking that provision is consistent with the Constitution and the better way to go. Justice Johnson, you talked about funding and how we would know what the legislature is going to do. Funding is always up, appropriations are always up. If this court were to hold on to the case for 1 year, it's the ever-evolving cycle of litigation is going to continue. So I think that's how we would address it. If funding is always going to be an issue with the legislature, as the Constitution requires. And part three, why dismiss instead of retain jurisdiction? As we've heard today, there are a whole host of experts out there that provide a whole variety of opinions, and they may impact particular districts in a particular different way. The best means in which to get to the bottom of that is a factual determination by a trial court. And I think that concludes my remarks. I would just ask that the court find this bill constitutional and at least compliant with Article 6, Section 6B.
Thank you, counsel.
Thank you.
We thank both counsel for your arguments this morning. Court will take this matter under advisement.